A very good evening to all the audiences and to Akanksha ma'am. I welcome everyone to Legally Speaking podcast with Rest the Case. Today we have with us Advocate Akanksha. She has been practicing in Delhi High Court and the District Court for almost 14 years and specializes in family law, including divorce cases and child custody cases also. Today, discussing what we are going to discuss is the topic of will. Akanksha ma'am, a big welcome to you as well. And I hope your insights and your years of practice and experience will shed some light on this topic.
Yeah, hi. Thank you so much for inviting me here.
So today, like I said, we are here to discuss about will. नॉर्मल इन अ लेमैन्स लैंग्वेज बहुत लोगों ने विल के बारे में सुना है। ऐसा कुछ विल ऐसी कुछ होता है ऐसा उनको पता है, बट उसकी लीगल डिटेल्स जब पिक्चर में आती है तो लॉट ऑफ पीपल गेट कंफ्यूज्ड और उनको
Correct.
लीगल गाइडेंस वैसे मिल पाती है नहीं मिल पाती है। सो आई थिंक इट इज़ अ वेरी इंटरेस्टिंग टॉपिक दैट वी हैव चोजन टुडे। लाइमलाइट वाला नहीं है पर आई थिंक एसेंशियल है।
Yeah, of course.
So let me just ask you a very basic question. How can you explain to a layman what a will is and उसके legal requirements क्या है?
Mhm. So, if I'll come to the layman language, death is something which is very uncertain and which can come at any stage, at any point of time, right? So, some people take it very lightly and some people take it very seriously. That's how the concept of will come into picture. So, the people who take it very seriously are really, bother about how they have to divide their estate, how they have to divide their property. Whereas there are certain people who believe that they don't want to, check on their estates and everything, and they want to follow the procedure of the law. Let's suppose whenever they are dying, they have to follow the procedure of the law. How is the estate is going to devolve upon their heirs, right? So that's how the concept of will is. It is always better and legally correct to make a will at a certain age or at a certain point of time. Of course, there is a age which has been given by the law that you have to be a major to create a will, right? So every person has to do that to be legally secure, and everything can be devolved upon your kids and your family happily. That's how the concept of will come into picture.
इसके like you just now mentioned that person has to be a major to make a will like above 18. So ऐसी और क्या legal
Correct.
requirements है that need to be there when you're making a will? Yeah, can I make a will being 30 right now, or do I have to like wait कि बुढ़ापा आने के बाद will बनाएंगे या कभी भी बना सकते हैं? So what are the legal requirements for that?
Yeah, no. There is the law doesn't say that you have to be old enough to make a will. The law only says that you have to be major, and once you attain an age of majority, you can definitely make your will. You can amend that will at any certain point of time. For example, you are buying more properties, you can always amend that will. So will is not certainly to amend it. All right.
And one question I had when you said that, there are these are the requirements. Let's say that a person is on his deathbed and he orally tells some parts ki ye property isko dena hai, ye property usko dena, and the person dies. Then is that considered an oral will, or does it have to be a written thing?
Yes, so it is also very important that will has to be in a written form. If you get I mean, it can be on a plain paper, something which is understandable to the person who's making a will. It can be in their native language, whereas the law does not say that the law does not put any mandatory condition that will has to be registered,
Okay.
right? It can be a registered will, it can be an unregistered will. If it is the register will, then it is better for the for the legal binding. If we say it is better for that, for legally it is better, the will has to be registered.
Okay.
But otherwise, if a person who is on a deathbed and he orally says that I want to divide this like this, it is not valid.
Okay. So it
It
is
has to be written,
all right. So
and of course signed by the
signed. Okay. So मैं ऐसे ही डेथ बेड पे कुछ बोल दूं and I pass away, then that will not amount to a valid will.
That will not amount to valid
Okay.
will.
And what will happen if someone passes away without making a will? मतलब if I have to tomorrow ask you for a legal advice कि आकांक्षा मैम will बनाना better है तो what are its advantages, what are the benefits, and what will happen if someone passes away without making a will?
See, if someone passes away without making a will, then that whatever the state is, that is called as person dying intestate, right?
Hmm.
So whoever is dying intestate is the property of that person is going to devolve on their legal heirs. Then it is vested upon the court how the property is going to devolve, right? It can be given to your to your children's, to your wife. If it's a female, then to the husband or parents. So there we have a class 1, class 2 hires in our succession act, so it will be devolved accordingly.
So in that case, the rules of the Succession Act will be made applicable by the court if you have died without making a will. Does that also differ from religion to religion since Succession Act, मतलब religion के हिसाब से इस Succession Act की applicability बदलती है या how is that?
So Succession Act is basically related and majorly of Hindu. He talks about Hindu dying intestate, and I have no clue about if it is Christian or Muslim dying intestate.
Okay.
So we are going to talk about Hindu.
Okay. So mainly Succession Act जब आता है तो those rules are mainly following the Hindu personal law. Uh, Okay, all right. And like you said, that will has to be signed, otherwise it won't be by the person making it. So what are such other elements that are considered essential for a will to be considered valid?
Yeah, so the first thing to consider will to be valid is that there is no general format, for a will, but it is always advisable to a person to, go to the advocate and get it drafted properly, so that advocate is also going to clearly mention all the important things which are needed to be mentioned in the will. Whereas if a person doesn't want to do that, he can also do it on his own. And the important factors to be considered while writing a will are that first of all, it should include all your assets, your movable as well as your immovable assets, and whoever you want to give those assets to, whereas it has to be signed by you, which is also important. And the third and a very important factor here is it has to be signed by the two witnesses.
Okay.
Okay, and those witnesses should not be the beneficiaries in the will. It
Okay.
can be any person other than the beneficiaries in that
Okay.
will. It can be your friend, it can be your family member, it can be your neighbor, anybody who is not interested in that particular will.
Okay. So by beneficiaries, you mean to say that जिसको उस will के through कुछ मिल नहीं रहा हो, such a person can be a witness to a
Yeah,
will. So they are not basically
yes.
benefiting out of
So,
that will. All right. Witness
yeah,
के कुछ
the will
specific
would not
rules है.
benefit.
Witness के कुछ specific rules है apart from the one you mentioned right now.
No, there are no other specific rules. It's just that witness has to be, of course, major, and he has to be related to the person who's signing it. That is all.
Okay. And witness होना will की validity, like you said, it is an essential element for a valid will that you have to have a
Yeah.
witness. Why do you,
Hmm.
according, like this is an opinionated question, nothing to do with law. Why are witnesses
Hmm.
considered important when it comes to will?
See, that has been see, there is certain formalities, which Registration Act also talks about. There
Mhm.
are certain formalities. So while registering a will, it has been stated that it is important to have two witnesses who are going to sign the will. So it can give more authenticity to the will that in front of these two witnesses, this person has signed this particular will. Nothing more than that. Those witnesses have no role to play other than this. It is also very that no witnesses, the will is considered void and it
Or
can be challenged.
okay, so मतलब basically witness होना is what you can say कि मतलब मैंने इनके presence में ये will बनाया है, so they can talk about its authenticity if it comes to that.
Correct. The
Okay.
authenticity person can be present in the court also if needed, to give an authenticity that will has been signed in presence of them.
ओके ओके एंड बहुत से पिक्चरों में विल इज अ वेरी सारे डायरेक्टर्स का राइटर्स का फेवरेट टॉपिक होता है व्हेन इट कम्स टू कोर्ट रूम ड्रामा सो वी ऑलवेज सी अ कॉन्सेप्ट ऑफ एन
Yeah.
एग्जीक्यूटर राइट कि मैं इनके विल का एग्जीक्यूटर हूँ सो व्हाट इज दैट कॉन्सेप्ट एग्जैक्टली लाइक एंड व्हाट रोल डज एन एग्जीक्यूटर प्ले
See, executor again is a person who should not be the beneficiary in that will, and that person should be related to the person who, I mean, the testator, a person who's making the will. And executor ka main role hota hai when after the death of the particular person, unke property ko devolve karna properly, taking care of the facts that whatever is written in the will, it has to be devolved accordingly, moving to the court, and a proper execution of the will has to be done by the executor, whereas the executor should have no interest in the will.
Okay, so basically someone who will see the entire process through is going to be appointed as an executor.
Yes. So, हाँ, so जो testator, I think जिन पे trust होता है उनको, I think testator can appoint that person as an executor. कि ठीक है मेरे बाद this person is responsible to handle, I think this
Okay.
person is responsible to handle things properly. That person should be the executor.
It's like basically like giving power of attorney to, अभी मेरे जाने के बाद आप, you have the authority to look into it and do things. So can this
Look into the.
executor be, and like, let's say I have made a will, do I need to
Mhm.
appoint an executor, specifically say that this person is the executor of my will?
You need to appoint that executor.
Yeah,
I didn't get your question.
I am asking if I made a will, do I need to
Mhm.
mention exclusively that I have appointed XYZ person as an executor?
Yes, that has to be mentioned in the will, that
It
this
has to,
person is the
okay.
executor. Yes, it has
Okay.
to be mentioned in the will.
And can that executor be, let's say I have an advocate who looks after my dealings and everything. Can that person be my
Yeah,
advocate?
absolutely. That person can be an advocate, can be an executor, a friend, a neighbor,
Okay.
anybody else.
Okay. But they shouldn't basically benefit like same like it is with the witnesses. All right. And
Yeah.
so like you said, there is no format of will that has been prescribed. It can be written
Hmm.
as it feels convenient. So where should I, like, let's say I am making a will, where should my signature be placed? Does that have any specific requirements?
See, there is no specific requirement, as I earlier also said. But whenever a person wants to make a will, I think a person should, which a layman should follow, is that you need to write whatever your assets are, movable assets, immovable assets, and everything जो आप देना चाहते हैं, and then you can write it that on a piece of paper, and then you can hand it over to your lawyer. He can absolutely correctly, with legal terminologies, can draft the will, and the will should not be in a very complex language. It should be, understandable to me, to you, to the testator, of course, who's writing the will. ठीक है? And the rest of the job has to be done by the lawyer. The
Okay.
drafting of the will, if it's done, and then after that, the testator is going to sign that will, and then it will go forward for registration and signature of the witnesses. So after signature of the witnesses, it will go for the registration process, and then the will can be gets registered, and the testator need to keep the original copy of the will.
Okay. Okay. So, like you said, registration is not a very compulsory thing in India when it comes to will. So, what are the pros and cons of getting a will
Hmm.
registered?
See, if I'll talk about the registration of the will, it is not mandatory to register a will, but it is always advisable to get a will registered.
Mhm.
See, if the will is not registered, it can be any number of will. unregistered will which will come your way.
Okay.
But it is in the record of the government, and the legal sanctity of the will is holds a very important role here. One benefit is that any person XYZ cannot bring in another will and show it in the court. Okay, this is also unregistered will. I have also got one unregistered will. Another person will also get an unregistered will. So there will be no transparency,
Okay.
right? So to avoid that, it is important to get your will registered.
All right. And when we talk about registrations, like we were also speaking about format of the will, you said that I can make changes to the will whenever I feel like. Like if I have made a will right now, I let's say purchase some property after that, and I feel like this should also go into my will. So what is the legal procedure to amend
Mhm.
the will that is made?
Okay, so the legal procedure to amend the will, there are two process actually. The first thing is you want to amend the will. That means you want to change the property in the will. For example, you have one property, now you've got two property, and you want to divide those two properties, and you've only mentioned one property in the will. So in that case, you want to alter that will. So codicil is one of the word which is one thing where you can amend the will.
Okay.
Okay. Whereas if you are unsatisfied with the will and you want to make a lot of changes in the will, then you can cancel that previous will and make another will and get it registered. So
Okay.
it is very important that the previous will should be torn and cancelled in the government records as well as, and you make a new will,
All
and
right.
you can do it at any point of time.
How long does it like usually take for one will to get cancelled and a new will to get registered? Like
Oh,
an
it doesn't take
approximate.
much time.
Okay.
It doesn't take much time. Once you make a new will,
Mhm.
the previous will can be cancelled within few weeks, I guess.
Okay.
That depends upon the state to state
State to
also.
state also. All right. All right.
Yes.
And
Hmm.
are there any specific kind of properties that are permitted to be given away in a will or are restricted to be given away in a will? कि ये property आप नहीं दे सकते हो in a will. For like I believe
Yes.
ancestral property is something that
Yeah.
maybe you can't give
Yeah.
away.
So two kind of properties are there, ancestral property and a self-acquired property. So it is a very common law which says that only self-acquired properties will can be made of only self-acquired properties, right?
Okay.
Not of the ancestral properties, because ancestral property has to devolve according to its own uh, format and its own legal terminologies. Whereas
Oh.
if I talk about an ancestral properties,
Mhm.
any property which you have owned, you have buyed, you have made self-made properties, if in
Mhm.
a simple language I would say, that properties can be mentioned in the will. It can be a car, it can be a property, it can be your gold, it can be your any other immovable properties as well.
ओके सो एंसेस्ट्रल प्रॉपर्टीज आप विल के थ्रू नहीं दे सकते हो बट सेल्फ अक्वायर्ड जो आपने खुद ने खरीदी है वो आप दे सकते
दे
हो
दी है, हाँ हाँ।
let's say that we have a situation where someone wants to give away an ancestral property उनके ancestors है नहीं
हम्म
तो obviously उनके कुछ
हम्म
legal heirs होंगे जिनके पास वो property जाएगी through ancestral तो is there any way कि NOC लेके या कुछ करके वो ancestral property भी will में add कर सकते हैं या it is prohibited altogether?
नो, एंसेस्ट्रल प्रॉपर्टीज में अगर आपने कुछ चेंजेस किए हैं, लेट्स सपोज आई गॉट सम एंसेस्ट्रल प्रॉपर्टी एंड आई हैव मेड सम चेंजेस ओवर दैट प्रॉपर्टी, आई फ्रॉम माय ओन मनी.
हम्म,
Okay. In that case, that becomes your self-acquired property,
okay.
right? So you can mention that property, of course. But otherwise, ancestral properties are totally, I mean, it's not your own
Own
property, na? You
property to
cannot
keep.
mention that in the will.
So until and unless nature of that ancestral property changes in any manner, आप उसको नहीं
Change.
दे सकते.
Yeah,
All right, all right.
correct, correct.
And previous also a lot of times you said that a will can be challenged in court. So on what grounds can this happen that a will has got challenged in court?
So, if I talk about grounds of challenging the will, there are various grounds on which a will can be challenged. First is that it is obtained fraud. Because of the fraud, it has been obtained due to coercion or undue influence, it can be challenged. Then the signature of the testator can also be challenged. Then there are other grounds like the revocation is also one of the ground. Okay, the person has not revoked the previous will. On that basis, also the will can be challenged.
Okay.
And apart from that, there are certain limitation as to the, of course, the age. If a person has written a will and is not in a particular age to write that will, then on that basis also it can be challenged.
All right. All
Apart
right.
from that, there are various other circumstantial grounds, on which it can be challenged. There are certain kind of lacunas sometimes in the will.
Mhm.
On that basis, a will can be challenged.
I think one movie that I can very well recall on will battle is I think Taxi number 911 जो आया था. Uh,
Yeah.
so that was also like a battle for the will. So have you come
Hmm.
across any such instances or interesting cases in your years of practice for this?
Not much cases if I talk about, but yes, I have had a conversation with one of my client who is a 70 years old man who runs a business, and he runs a business with his son.
Okay.
Okay, and the son is also unmarried, and the daughter is also unmarried.
Okay.
So, what he wanted was he wanted to give the entire business estate to the son,
Mm-hmm.
whereas he was very skeptical that it should be given to the daughter or not, right? Because according to him, if he will make a will and give the entire thing to the son, the daughter is not going to be happy.
Correct.
Right, the entire business to the son, the daughter is not going to
Mm-hmm.
be happy, and he believes that the daughter is going to challenge that will. And
Mm-hmm.
on the other hand, he also thinks that because I have raised my daughter like that, and the daughter is ultimately going to get married, and everything has been invested and being done by the son in the business. So what is the point of giving to the daughter? So we had a really good argument in this, that giving to daughter, he believes that giving to daughter is also unfair, and not giving to daughter is
Daughter is
also going
also
to be
unfair.
unfair. So
My
he
God.
was very skeptical. Uh,
Mm.
he wanted to make a will, but he was not able to figure out how he's going to. And if he'll not make a will, then ultimately that business will devolve upon both the son and
Correct.
daughter.
Correct. So he had
So
to make a
not
will.
making a will, yeah. So not making a will is also not going to be a good a thing to do, I think.
I think
So yes, that was
everyone,
one of the
yeah.
interesting argument we had.
I think everyone who is at that stage that, they've probably crossed 40, 50 should honestly think about making a will so that उनकी property उनके हिसाब से divide होगी. Otherwise, then it follows the rule of law that has been written.
Of course, तो daughter को तो वैसे ही property में से मिल ही जाएगा, even if he doesn't want to give, but for that he has to write the will.
Correct,
So
correct.
that is how I was telling him the importance of making a will.
Oh, lovely. So I'm very sure you must have come across many more such interesting cases as you have a lot of years of experience
Yes,
and
yes,
practice.
absolutely.
Last question I want to take
Yeah.
is while drafting or writing any legal document, there are a lot of common mistakes that people make. So, what are these common mistakes and how can you avoid making those while making a will?
Yeah, so the only factor which I want to tell you is that people try to make a will in a very complex language, making a lot of adding a lot of legal terminologies to it and difficult wordings
Mm.
and all those things. I think it should not be done. Everybody, even if it is an advocate or a layman who's writing a will, people should avoid writing difficult terminologies in uh, I mean, in making a will. Whereas on the other hand, a simple language which shall be understandable to any other person is very important to write in the will. And also, apart from that, I think it should be signed by the testator. That is the most important thing.
Correct, correct. And
Yeah.
the witnesses,
Mm.
that's it.
Yeah.
Okay. Lovely. I think that's all the questions that I had. I'm sure that, if people have any more questions, they will definitely get in touch with us. But thank you so much for your time. It means a lot to us that you took out time from your busy schedule and, came and had a conversation on this topic. I look
You're
ahead
welcome.
to
You're
I look ahead to many more such other topics of interesting conversations that we will have ahead.
Yeah, thank you so much for inviting me. I also had a very lovely conversation with you. I think the time worth it's worth spending time we had.
Definitely. We should
Yeah,
talk, people should talk about these things more.
definitely. Yeah, people are very much unaware and people consider will as something very suspicious and something which is, oh my God, you are making a will. It's like that. It's like that situation in the families. I have seen families who are making a will, and there is a lot of drama in the family that why the dad is making the will and why the kids want dad to make the will.
Mm,
So people should normalize these things. It is important factor nowadays.
mhm.
It is
And
important for the kids also to understand that writing a will is
will
important,
is
and in fact
important.
for the parents also. There are parents who are orthodox and they believe, अच्छा बेटे ने हमको बोला will लिखने के लिए, why should we write? So
इसको
people
मेरी
should
प्रॉपर्टी में
normalize all
हिस्सा
those.
चाहिए.
हाँ, but actually वो अपनी लीगल उससे बच रहा है कि he doesn't have to face a lot of problems. Death is very uncertain. People should understand and normalize these things now.
Correct, correct. I'm very sure people who are going to listen to this podcast will definitely have some insightful and useful takeaways that they will get from whatever knowledge that you have shared. So I thank you once again for your time and you have a good evening.